Welcome to the Tough Decisions Network. This is our special Saturday edition called Step Up Your Game with Dan. I'm your host, Dan Handford, and I'll be discussing topics to help you make better decisions to increase your productivity, increase your sales, and improve your overall marketing. Visit toughdecisions.net to sign up for our free weekly entrepreneur email. Before we get started, let's hear from one of our sponsors. Have you ever thought about investing in real estate, but find yourself so busy that you don't have time for it? Do you have FOMO, which is the fear of missing out? At HandfordCapital.com, we help investors with passive real estate investments that project better returns than traditional investment vehicles such as the stock market. If you'd like to find out more about our passive real estate investments, visit HandfordCapital.com. That's HANDFORD Capital.com. We will jump on a call with you to discuss your investment goals and to see if our investments are a good fit for you. This advertisement is not to be construed as an offer or recommendation to buy or sell a security. Visit HandfordCapital.com.
On the podcast with us today is Richard Goldstein. Rich, thank you for coming on to the podcast with us today.
Oh, my pleasure.
Why don't you start us off by giving us a little bit of a background about who you are and what your current focus is right now?
Okay, great. I work as a patent attorney. In other words, I help inventors and entrepreneurs to protect the ideas that they have, the inventions that they have. Something I've been doing for just about 25 years now. And I've helped about 2,000 companies get patents to date, which is a pretty big number. I'm 48 years old at the moment, but if I was 75 and about to retire, that would still be a very big number. So I've hustled quite a bit. I consider myself to be an entrepreneur and a marketer as well. I started my own practice when I graduated law school, which is something pretty unheard of as well. Typically, most attorneys that are on their own or aren't working at a big firm, they initially started at one, and they, at a certain point, took some of their client work with them and started the business. So for me, I basically started from nothing. What I did was I started a magazine for inventors that explained a lot of the patent process, talked about various issues that they were confronted with as they tried to pursue their ideas. And I advertised my law firm in that magazine. So basically, I was doing content marketing in the mid-90s before such a thing existed.
So lots of things that I wanted to dive into here, because I know as entrepreneurs, we have a lot of questions that come up. And I know in the green room, I kind of told you about a little situation that I had gotten into, some sort of a lawsuit. And so I want you to first start us and talk to us about why is it important as entrepreneurs for us to be thinking about getting a trademark or being able to patent something?
Well, I think on a fundamental level, when there's something of value there, you want to protect it. So fundamentally, when you're starting a business, there are certain things there that may or may not be important to the success of the business. Sometimes there's an idea underlying what you're doing. Sometimes there's a product that you're launching, and there is something that's distinct about that product, and preventing competitors from coming too close to your territory, stepping on your toes by making a similar product may be important. Other times there's a name that you're using to promote the business, a trade name. And there are, as you grow the business, there are competitors that would like to have some of the success that you're experiencing. So one of the ways that they might do that is by confusing consumers into thinking that their company is your company to ride on your coattails. So it's important to think about this stuff because you want to be aware of just about any other fact, just as you're aware of other factors that may be a factor in your success, things that competitors might want to copy and duplicate and cut into your market share. You want to be aware of these things. You want to be aware of your ideas, your intellectual property.
So many people get confused between what a patent is and what a trademark is. You know, I've heard people before, they're like, oh, I patented my logo. And I'm like, you can't patent your logo. But can you kind of dissect a little bit for the listener? What is a patent and then what is a trademark?
Yeah, so super simple then. Patents deal with products and ideas for a product, where a trademark would be for the branding that you use to sell the product. So kind of the things about the product itself that are unique would be something that you would potentially patent. And the way in which you portray it in the marketplace, the name that you use to promote the product, the logos or other branding aspects that you use to set it apart. Those are trademarks. And lastly, copyright generally is dealing with content of various types.
Which is a lot harder to protect than some sort of a patent, getting a patent or trademark on something.
Yes, well, what it is with copyright is that the thing that you're protecting is perhaps not what you would want to protect. In other words, with copyright, the protection is for the concept itself. It isn't for the ideas that are underlying the content. So whether it's a book or a painting, you would like to think that you can stop other people from making a similar painting or writing a book that really copies the idea that motivated you to write the book, the thing that you thought would appeal to people. But that's not what the copyright protects. It doesn't protect the context. It doesn't protect the ideas. It protects the content, the words that you use, the images that you created in that painting. That's what gets protected. So it prevents direct copying, for sure. It prevents people from downloading your videos and selling them or distributing them without your permission. But it doesn't prevent people from shooting their own videos using similar ideas.
So I want to dive into the patent process just a little bit, or maybe not just the process, but the different types of patents, because I watch Shark Tank, which I know a lot of entrepreneurs do, and one of the top questions they say is do you have a patent? And they, of course, certain patents hold greater weight than others, and of course there's certain, like pending patents or provisional patents or whatever, and then you also have those, I always hear on there utility patents, and they always get really excited when somebody has a utility patent. So can you break down the different types of patents?
Yes, absolutely. So really, there's only two main types of patents that you would be at all concerned with as an entrepreneur. One is a utility patent, and the other is a design patent. So a utility patent is what you're typically thinking of when you think of a patent. You think of a product, and it's got something different about the way it functions. It's got some type of different functionality, and that's what a utility patent protects. It protects that functionality. It protects that different structure that's there for a functional purpose. A design patent, on the other hand, is simply for the look of a product, what they call the ornamental appearance of it. So you have a telephone that is shaped like a duck. That's what a design patent would be for. Nothing different about the way that the telephone functions. It's just that it has that unique shape, and that's what you would want to protect with a design patent. So when you apply for either of those patents, then it's considered patent pending. So patent pending means you've put in a patent application. It hasn't yet been considered by the patent office to decide whether your patent would be granted. But during that time period, after you've submitted, after you've established the fact that you have, let's say that you're the inventor of this, effectively you establish priority when you file that application. Priority so that if someone files an application after you, you would be ahead of them. So patent pending is usually an appropriate time for you to get out there and start telling people about your product and possibly even start selling it, because you've established your rights as best as you can by filing the application. And it's true that the patent office hasn't yet decided whether you're going to get a patent, but no one's going to sneak ahead of you to get their own patent, because yours is in there already. So that's patent pending. Now, there is something also called a provisional patent application. Now, a provisional patent application is a stepping stone toward a utility patent. So instead of filing that utility patent application, which will be reviewed by the patent office to decide whether it will be granted, you can file a provisional application. You file the provisional application, it's like a foot in the door at the patent office. It also establishes your priority, but it's not going to be reviewed. It simply buys you a year to finish it up and file that utility application. So you file the provisional application, it gets you patent pending. You perhaps go out there and start talking to people about your product, knowing that you've established priority, and things are looking good. And so within that year, you file that utility application. And when you do file the utility application, they give you credit for when you filed the provisional. So if anyone had filed in between, you still have priority over them. There's one major caveat to this, though, that I need to say, and that is that the priority you get is only as good as that application is well written. So sometimes, because that provisional application is not going to be reviewed, people file their own brief description, something they wrote up themselves, a few paragraphs describing what the idea is. And they file it, and they can legitimately say it's patent pending, but that thing that they filed will give them a false sense of security, because if they ever needed to rely on that description that they filed to defeat someone that didn't actually beat them in time but filed a utility application after, so they're looking to rely on that provisional and say, hey, wait, I filed my provisional first. It won't be good enough. It just won't be good enough to defeat that person who came along later. So the caveat is that for a provisional to effectively work, it has to be well written.
So how long does a patent actually last?
A utility patent expires 20 years after it's initially filed, and a design patent lasts for 15 years after it's approved and issued. So let's say 15 to 20 years.
So the design patents are 15 to 20 years after it's approved, or the design patent's 15 years after it's approved, and then the utility is 20 years after the application has been filed?
Yes, the latter. Sorry if that was confusing. So a utility application is good for 15 years after it's approved, and a utility application will expire 20 years after it was initially filed.
Okay. And so obviously there's these provisional patents that people have. Do some people like design certain things, whether it be the design or the utility patent, and then they put the provisional on there, and then they try to sell their idea or their concept to somebody, and then they sell the patent along with it?
Yes. Well, I mean, in terms of selling your idea, so finding a company, let's say, that is interested in buying your idea, buying your intellectual property, the important thing is that you have some type of rights, some type of leverage that they'd be willing to purchase. So if you have a patent that's been approved, you have an issued patent, certainly that's more valuable than if you have simply filed the application, and then it's simply an expectancy of whether you're going to get a patent on it. So that application, it may be accepted, it may be rejected. Now, every patent has a scope, meaning some patents are broader than others. So once you file an application, you still don't know how broad that patent's going to be. It might be accepted as is in a very broad format, or the patent office might really limit the scope of the patent to perhaps just the details. So when you file an application, you have something less valuable to sell. But certainly it's possible that a company would see what you're doing and say that it's important enough to get a jump on the market and license it from you as is, even knowing that it's not certain how strong your patent rights are going to be. So having an application filed certainly gives you leverage to make a deal, but not as much leverage as if you had the patent. You might say it's the difference between owning a stock or owning an equity and having an option of some sort. You don't really know what it's going to be worth.
How often are these patent applications, reviewed and then just outright denied? Or is there like a process of them saying, hey, these are the areas that we see are discrepancies? Or what's the process for being denied those patents?
Yeah, I would say most applications are initially rejected. And when they're rejected, though, we have an opportunity to respond and to present appropriate arguments that the application really should be approved. So whereas most applications are initially rejected, if we do have an opportunity to respond, most of the time we're successful in convincing them to grant it. So I would say overall, don't know the exact statistics, but I would say somewhere around 75% of patent applications turn into patents.
Wow. Turning to the table just a little bit, if you're looking at a product that you've come up with like a different slant to it or something different to it, how much of that particular product or design do you have to change to be able to get your own patent on it?
Okay, well, the standard is non-obviousness. Basically, what that's saying is that whatever's different about it can't be something which would be obvious to people in the field. It's a rather subjective standard, and people can differ in opinion on that. but basically just to give you an example of what would be obvious. So you want to make a ballpoint pen that's 8 inches long, right? Typical ballpoint pen sitting on your desk might be somewhere around 5 inches long. You submit a patent application for that. The examiner at the patent office might not find an example of someone specifically saying that their ballpoint pen is 8 inches long, but that's the type of thing that would be obvious to people that make ballpoint pens, is that you can make it whatever length is reasonable for whatever the intended purpose of it is. So it's kind of like when things fall within the expected range, people that are designing products in the field, there's a certain range of things that they borrow from or that they might think to do. When something is obvious, it's in that range. Even if you can't find a direct example of someone doing exactly that, if it's kind of within the realm of what people in the field would think of, would consider obvious, then it's not patentable. So bottom line in all of this is obviousness. That's how different it has to be, is it has to be a non-obvious difference.
And so it sounds to me from that description that it's easier to kind of get around or change that obviousness from a design patent versus a utility patent, which is why when you listen to shows like Shark Tank, they get really excited about the utility patents. They hold a little bit higher weight or heavier weight to them.
Yes, and so when it comes to design patents, again, it's just for the appearance that you depict in the design patent. So if you change the appearance, you're going to not be infringing that design patent. And so often when someone has a functional product and the sharks hear that they just have a design patent, then they realize that the person before them doesn't really have much, because all you need to do is give it a different appearance and it wouldn't infringe. So with a utility patent, it's more likely that you could protect a concept. It's more likely you could protect a conceptual idea of a new feature for a product, a phone that has a certain functionality, a mop that has a certain type of quick ringing or quick release or something like that. The sharks would be looking for a utility patent on something like that.
Yeah, so when you're talking about the functionality being what you're patenting with a utility patent, are you more patenting the outcome of the function or the process to get to the outcome of the function?
Yeah, the way in which you get to the outcome. You typically can't protect an outcome. It's a structure that gets you there, or a process that gets you there. And that's what you're protecting is whatever's different about that structure or different about that process from things that have been done before.
So how much does it cost to actually go through that process of getting either a utility or a design patent?
Utility patents typically between $10,000 and $20,000, and a design patent is a lot less expensive, typically a few $1,000s for a design patent.
And how long does it take to get either one?
About a year or two.
Okay. So it's pretty wide open just because of that process of having to probably get initially denied and going through the process of appealing and stuff like that.
Yeah, exactly. And you're correct also in what you were saying a moment ago, that with the design patent, it is much more likely that you're going to have it granted. So the whole key with the design patent is to properly present the design. So the drawings have to be 100% consistent between the different views. You present views of the object from every angle, and one of the biggest considerations when they're reviewing it is how well the drawings were done, whether they're perfectly consistent. Usually has a lot less to do with comparing it to other items than it does making sure that the design was presented correctly. So with design patents, it's about 90% that they're going to go through, especially if it was done correctly.
Mm-hmm.
Utility patents, again, about 60, 70% of the time it will be rejected. And a lot of times in response to the rejection, what we're doing is we're taking a closer look at what makes the product distinct. So they're citing examples of some things which might have fit our initial definition of the product in the patent application. And what we're doing in response is we're tailoring our definition a little bit so that perhaps we're going a bit more into the details and using that to distinguish our product from the prior art, the things that have come before. And this is the key, though, also to establishing what the scope of the patent is going to be. This is how patents get narrower, is when you start to get into the details to show how it's different from the prior art. The problem is that as you go into the details, you're departing from the concept a bit. So the extent to which you think you may be protecting a whole new concept of a feature, now you're getting more into the details of those features. And for someone to infringe, they have to then copy those details. And this is where the myth emerges about people can just change a little bit about your patent and get around it. And what it is that if your product wasn't as new as you think it is, then you're going to have to rely on some of those details in order to get your patent. And now you're getting a patent that it's much more likely for people to change something and get around. But the real truth of that situation is that you didn't invent the concept to begin with. If you're getting that far into the details, it means that it wasn't as original as you think it was. So the person who you think just changed one thing, they're actually doing the portion of your invention that was already old, that was already not your invention.
Now, what if you had, designed a product or, a process and didn't go through the patent process, and then somebody else did do it and they kind of, quote unquote, maybe necessarily didn't steal it, but they also did it and they filed it before you? Is there any way to show them that you did it before them and kind of appeal that process? Or are you just out of luck?
Yes, well, that's what first to file is. And for the past several years, we've been in a first to file system. It used to be that we were the only country in the world where if you invented it first and you could prove you invented it first, you could prevail even if someone else got to the patent office before you. And now that's no longer the case. So in the US, it's first to file. So the first person to file the patent application will prevail, even if the other person can prove they've been working on it for 10 years.
How do you protect your invention before you go through that process when you have to bring on other people to try to maybe help you design or develop that product?
It's definitely a challenge, but usually what you need to do is file a patent application based upon what you know now, and then you can safely talk to other people about what you're doing, and perhaps you do a further application once you've made improvements on it. And in fact, a lot of companies pursue that strategy anyway. They initially file an application when they have the initial concept. And as they improve the invention, they file further applications that may lead to additional patents. And a lot of times you'll see a product that has numerous patent numbers on it. And it's often because they took that approach. They filed initially, and then as the process developed, they filed additional applications to pursue the additional improvements and the new features that they came up with.
So it sounds to me like you should be the first person that somebody contacts in a situation where they have this idea, or not really an idea, but they have a product that they want to put a patent on or something like that before they really start to try to, really announce it to the world, if you will.
Yes, absolutely. You really do want to get your application filed before you let the cat out of the bag, as they say. There's another aspect to that as well, and that once you publicly disclose an invention, you quickly lose the right to file a patent application ever. So if you've publicly disclosed an invention and you haven't already applied for a patent, you immediately lose the right to file a patent application in much of the world. In the US, there's technically a 1-year grace period where if you publicly disclose it and you file your application within a year, then you can still get that patent potentially. But if more than a year goes by, it's absolutely too late. Even if no one else has copied your idea, even if no one else has jumped in and done anything sinister, your own public disclosure will act as a bar to you getting a patent.
So let's shift gears here a little bit. I want to talk about the trademark side of what you do as well. So obviously, the trademarks are more about, like you said earlier, about your branding more than obviously what the patents are doing, which is more of that product, the functionality, the design, that kind of stuff. It's more of the branding. So let's just say, for example, you have this product and you wanted to name it something, and then you might trademark that name, correct?
Yes, exactly.
So whenever you see a logo and it has TM versus an R, correct me if I'm wrong, but TM means that it might not necessarily have been filed, or it might have been filed, but it's not approved yet. But once it gets approved, then it gets changed from a TM to an R.
Yes, you're 100% right on that. TM is basically a person asserting their common law trademark rights to a name. So you're putting other people on notice to the fact that this is a name that I consider to be a trademark for my business. It's not just a term I'm using to describe something. It's a name that I consider to be a distinguishing point for this product associated with my business. And just to let you know what that is, common law rights. So basically, when it comes to trademarks, when you're using a name out there, you do acquire rights to it, even without having filed an application. So if you were Outback Steakhouse and you start selling a product called the Blooming Onion, the extent to which people know of the Blooming Onion is the extent to which you have common law trademark rights. One of the problems, though, is you need to prove it. So if another restaurant started selling Blooming Onions, then you would need to show that the public considers Blooming Onion to be something uniquely from Outback Steakhouse. So the common law rights exist, but they're not as strong as if you go through the process and get a registered trademark. So you start selling a product under a certain name, you could put the TM next to it, but then if you go that additional step and you file an application for a registered trademark and it's granted, then you could put the R with a circle around it, which means registered trademark. Oh, and the thing I wanted to say about that then is, then the protection extends even to places where they've never heard of you. If there were only Outback Steakhouses in the Southwest of the United States, and perhaps you could prove that people in the Southwest of the United States knew of Blooming Onions, once they had a registered trademark, it protects them throughout the United States. So even in New Jersey, where perhaps no one had ever been to an Outback Steakhouse, or one hadn't existed in that state at least, then the trademark rights from that registered trademark still exist. So that's the advantage there, is you don't have to prove the extent to which the public knows of it, and those rights extend even in places where you haven't done business yet.
So talking about these trademarks, how well protected are they in different business categories? So, like if somebody has, say, just to give you an example, large company, Nike, right? They usually command the apparel business, right? Shoes, shirts, sports gear, that kind of stuff. Could you then use that same, word, Nike, into a different business, like, Nike Foods or something like that?
Okay, excellent question, and bad example. And I'll tell you, and you'll see why in a moment.
Sure.
So trademarks are specific to the area in which you apply for them. So let's say a certain brand name being used for apparel wouldn't preclude someone from using that brand name perhaps for an office supply company. And that's generally the case. So generally, trademarks are specific to the goods and services for which you apply. But when it comes to Nike, Nike is such a famous mark that if you saw a pen with the name Nike on it, you would think it was an official pen. If you saw a Nike restaurant, you might think that that was the official Nike restaurant. So when there's a mark that's that famous, you really can't come even close to it. A prime example is McDonald's. So, if you opened a shoe store called McShoes, people might conceivably think that that was associated with McDonald's. And so McDonald's would quickly put them out of business. So, like I said, there's an excellent point, but bad example, because when it comes to famous marks, those rules don't typically apply.
And are they protected by trademark law, or are they protected because they have the bigger pockets and they can basically just shut you down by just fighting the legal battle as long as they want?
A little bit of both, but really what it is that trademark infringement is about likelihood of confusion. Whenever you do something that would likely confuse a consumer, that's when you have trademark infringement. That's when you have a trademark violation. So when it comes to non-famous marks, like much smaller businesses, if someone is selling apparel under a certain brand, and then there's a restaurant under that same name, there's not much likelihood that people would be confused. But when you have something that's as famous as Nike or McDonald's, then there is an actual likelihood that people would be confused. So even though the company does have deep pockets and might pursue things that other companies wouldn't, they can make a legitimate case that people would likely be confused into thinking that there was some affiliation between that other business and themselves.
Now, would there be any protection for that person if, let's say, before Nike even came out, there was a, I don't know, let's just say a Nike restaurant, right?
Yes.
Nike burgers. And then all of a sudden Nike comes on the scene and it gets this really well-known name called Nike. What happens there?
Actually, the big company Nike, their rights would be subject to the person who could show that they have common law rights that pre-existed.
That's when you're going back to who's got the bigger pockets.
Yes, potentially. Okay, so then we can say theoretically. So theoretically, that person would prevail.
Mm-hmm.
But if you look around the world, and I can't think of a specific example right now, there are times when you see a business and you say, how could they possibly be in, or at least me as a patent and trademark lawyer, I say, how could they possibly be in business? That's just like a famous mark. And then the answer typically is that they've been in business since the 50s. They've had a mom and pop store under a certain name that you would say, how could they possibly be named that? But their store actually pre-existed from that bigger player, and the bigger player knew better than to go after them, or they maybe started to go after them, and after a little bit of investigation, they realized that it wouldn't be a fight that they would win, and it wouldn't look good for them to just simply crush them from having greater resources.
Well, and the reason why I bring this up is because this actually didn't happen to me, but it happened to somebody that I know in the chiropractic space, where there was a large national franchise that came on the scene, and then they actually had a name very similar to it. And then after they became well known, they were filing lawsuits against these, several chiropractic offices that had similar names. And they basically had to change their name because they didn't have the money to be able to fight it, to be able to basically say, hey, we had this before you even guys came on the scene, and we're not even exactly named as you, or we just have some of the words that's in yours inside of ours,
Yes. Well, it certainly happens. And I guess the point is that the Goliath then going after the David is rolling the dice, that the David in that situation would challenge it and potentially win, and potentially leave the Goliath with less trademark rights than they started with.
Well, Rich, I could talk about this stuff all day long. I love this topic. I think we should have you on a future podcast because I know you're really busy. I thank you for coming on with us. How can the listeners reach out to you if they want to get more information about patents and trademarks, or just have some questions for you?
Okay, great. Well, a few things I would say is, first is, if you want to find out more about my firm and whether it's a match for us to work together, the website is goldsteinpatentlaw.com. And there's a lot of great resources there as well for people that are looking to learn about the process. We have videos that explain what the process is and how it all works. It's really helpful to find out before you jump into all this. Also, I wrote a book for the American Bar Association. They asked me to write a book explaining how patents work, but explaining it in plain English to entrepreneurs. And so that's the ABA Consumer Guide to Obtaining a Patent. And that's available on Amazon. It's actually very inexpensive. It's typically around $15, depending on what Amazon feels like doing on a particular day, what they want to sell it for. But that's really it. I mean, I highly recommend for people considering going into this, considering filing a patent, to really learn the process. As I said, there's free videos on my website, goldsteinpatentlaw.com, and you might also consider checking out that book, the ABA Consumer Guide to Obtaining a Patent.
Well, Rich, I really appreciate you coming on, and we will make sure that all those links get put onto our show notes for this episode so the listeners have easy access to those. Thank you again for being on. Look forward to following you some more and having you on a future episode.
Absolutely. That all sounds great.
Thanks.
Thank you for listening to the Tough Decisions Network. Be sure to visit toughdecisions.net to gain access to show notes for this episode and to join our free weekly entrepreneur email, where we will send you news about the latest technology for your business, inspiring quotes, and the latest books for entrepreneurs. That's toughdecisions.net.